You're listening to the Max Planck Lawcast, which showcases the academic research currently being conducted across the Max Planck Law Network. I'm your host, Christopher Murphy, and together we'll be talking to some of the more than 400 researchers who are pushing the frontiers of legal knowledge in Germany and abroad. When it comes to new and exciting legal research, the Lawcast has you covered. Well, thank you very much for tuning into the next episode of the Max Planck Lawcast. As always, it's wonderful to have you here with us today. On today's episode, we're going to be talking about how the common law was transferred to India. In particular, we'll be charting changes in the way that the law was communicated and represented over time, beginning with the commercial interests of the East India Company through to the direct rule under the Crown. We'll also be assessing the role that certain philosophical ideas had on this legal transfer. To do so, I'm joined in the studio by Erika Ollikainen-Reid. Erika is currently a doctoral student at the Max Planck Institute for Legal History and Legal Theory in Frankfurt. Welcome to the program, Erika.
Hi, I'm pleased to be here.
Great to have you with us today. So, based on my calculations, we've got 2 centuries of law to go through in roughly 20 minutes. It's going to be a challenge, so why don't you begin by maybe telling us about the aim of your doctoral project and what it is that you're exactly hoping to achieve?
So this project really developed from a long-term interest of mine in how the law is communicated, and that even applies to today as well, from today's perspective. But the aim of this project specifically is to reconsider the law as a channel by which colonial authority could be communicated to the colonized people of India, and in particular how this changed with the shift from East India Company rule to Crown rule, so that is direct rule from London.
Okay, right. Then if we're going to be starting from the shift from the East India Company to direct rule, let's maybe start with the East India Company, and if you can maybe give us a rundown of its role in India.
It's a long and complicated history, but to boil it down to a little bit of a sweet sauce, English presence in India began basically as a commercial enterprise. From about 1600 onwards, various royal charters and monopolies were granted by the monarch, the English monarch, to merchants and businessmen, which allowed them exclusive trade first in the East Indies and then a bit later in the Indian subcontinent. And broadly speaking, the main commodities they were after were spices, then Indian textiles, cloth, and other raw materials. It's important to note that India itself was not a single unified country for actually most of its history. It was made up of a number of individual princely states, local societies, quite diverse. Broadly speaking, the company then became another one of these societies or entities. So it was in there in the mix with these other princely states. But eventually the company grew into a huge corporation, which today we might compare with the likes of Amazon, Google. The difference being that the company owned parts of India on trust for the Crown. It had some parliamentary oversight from London, but not a lot, at least to begin with.
Had the East India Company, in this essence, shareholders or directors, CEOs? It was a company that we would understand today, as you say.
Broadly speaking, a company as we might understand it today, like Amazon or Google, a lot of shareholders, and they were direct investment shareholders. So I would say that there was a lot of noise, as it were, from them, and they were sometimes at odds with Parliament, who wanted to keep some kind of control over the situation, but ultimately the company was responsible to its shareholders.
Okay, right. There's often a debate today about that as well, isn't there? Who a company should be there for. How was the East India Company kind of viewed by the local indigenous Indian populace? You say that it kind of existed parallel to a number of other states there. Was there then cooperation between the Indian states and the East India Company, or was it seen as a source of irritation with them setting up their trading posts?
I would say it's a mixture of both, is what the history that's already been written tells us. The company used a mixture of mercantilist strategies. Of course, famously, they had their own huge armies, but they also used diplomacy to seek particular trading rights, to seek political favor from the Indian rulers there at the time. So in a sense, yes, the early company rule was based on a form of cooperation with the Indian societies and rulers who already existed. In the medieval to early modern period, it was the Islamic Mughal Empire that was the biggest power, especially in the north, and they had brought a bit more of a central and systemized rule to the areas which they ruled. So the East India Company developed a relationship with the Mughal emperor and his government. They gained what were called farmans, which you might describe as decrees or rights for certain activities. And then crucially, a big date is the 1757 Battle of Buxar and then the Battle of Plassey, where the company was granted tax collection rights by the then Mughal Emperor Shah Alam II. So the company was then given these rights to directly collect taxes in the regions of Bengal, Bihar, and Orissa.
And who was the battle between there?
So it was very complicated because a number of belligerents, but broadly speaking, you could say that it was the company and some Indian states that were on their side and the Mughal emperor.
Oh, okay, right. And the company basically had its own mercenaries, if you will.
Yeah.
Okay. How did the East India Company apply law in their trading posts? Where did their law begin and where did it end?
Yeah, so over the years, as I said, parliamentary oversight began to grow. And in 1773, the then English Parliament passes the Regulating Act, which allows the company to write and administer their own laws in its Indian territories, so long as these laws were not repugnant to the laws of the realm. So they were given the authority to...
I love the word repugnant.
Yes.
We need to use that more in podcasting.
I had to be careful to make sure I pronounced it correctly. Yeah, so they were almost given a free rein with this quite small caveat, as long as it's not repugnant. But I would say from what research I've done, as I said, because it was a commercial enterprise to begin with, these people who are in the company employ, these administrators, they didn't go over there necessarily with the idea of changing the laws fundamentally or bringing English laws to India, at least in the first place. So there was little need, I would say, on their part, certainly to legislate for the Indian people.
Right.
And of course, the Indian people had their own rulers and emperors who were legislating sort of the more personal laws for them. So at first I would say it was quite limited.
Okay, and probably in the realm of contract law and these kind of things, if at all?
Where it affected them, where they had their own commercial and contractual disputes.
Okay, right. Now, I've done a bit of my homework and looked over your research page and some of the things you've been writing about, and it seems that the year 1833 is particularly important, and that's where your project formally begins. What's so significant about this date?
Yeah, so like I said, over the years, the company had come under this increasing scrutiny by Parliament. It was thought that their way of running commercial activities was becoming unviable. But because India by that time had become such a quote-unquote cash cow for Britain, it was a project that couldn't fail. So it was 1833 that the Charter Act, or one of the Charter Acts, was introduced in Parliament. And this basically wound down the commercial activities of the company. So the company still existed, but they were not allowed to trade anymore. They instead became a purely governmental and administrative body. So this is where my project sort of begins in earnest, because this is where you start to see a renewed interest in legislating specifically for India, transplanting some of the English laws and the associated, let's say, moral values from England to India. So under the Charter Act, a Governor-General, a law commission, a council for the Governor-General, they're all appointed, and we really see the beginning of this shift in legal authority from the company and their relationship with the Mughals to British Parliament, and then subsequently the Crown.
Okay. And why was this decision taken by the British Parliament? Was that then the end of the East India Company as we know of it in this period, or...?
No, it was sort of the beginning of the end.
Okay.
So since the company's formation, every 20 years, Parliament had renewed the situation, and there would be a new Charter Act every year. So it was literally renewing the East India Company's charter, so renewing their permission.
Okay, their permission
to
be active there.
But it was the Charter Act of 1833, I think, which was a significant step in maybe this is getting a bit out of control and stepping in to rein back a little bit.
Oh, I see. Right, that they wanted more direct control about what was happening there.
Yeah.
Okay. So, well, how does then colonial rule in India progress then over the ensuing decades once the Parliament makes it a crown colony and becomes far more involved?
Yes, so the biggest flashpoint in my project is what's alternately known as the Indian Mutiny of 1857, is also sometimes called the Sepoy Rebellion of 1857, or the First Indian War of Independence even. But briefly, this was where Indian soldiers in the company's employ rose up, denounced the company rule, denounced English rule, and symbolically they tried to proclaim the Mughal Emperor Bahadur Shah II as their true leader. And it was, of course, extremely bloody, but eventually the British won back control, and that had huge real-term but also symbolic significance. And
they sent out their own forces then from Britain?
Yeah, they had to scramble to sort the situation out.
Okay. Mm-hmm.
It was unprecedented, and initially they weren't prepared, so it was a big scramble. But this is a central turning point in terms of law and the sources of legal authority, crucially. And I categorized them by 3 events that happened in quick succession. So the first is that the Emperor Bahadur Shah is tried for treason, and he's exiled. And
by the British...
Interestingly, by a military tribunal, a British military tribunal, which is very interesting. So he's exiled. So he no longer exists as any kind of judicial or authority figure. So he's gone. The East India Company is dissolved completely, and its Indian territories were, quote unquote, given back to the crown.
Okay, so that is the official end then of the East India Company.
So it's 1858, the India Act of 1858, which marks the end of the East India Company. And that means that the Crown, and this is the approach my project takes, is that now the Crown and the British Parliament are the ultimate source of imperial authority in India. And as such, they almost have to create this PR campaign to present themselves and English law as being righteous and wonderful and good for you.
Okay. Don't go away, because we're going to have plenty more for you after this short break.
Welcome to Max Planck Law, one of the world's largest networks for legal research, based in Germany. Our world-class institutes invite applications for fully funded PhD and postdoc opportunities in almost any area of law. Join a thriving community of over 400 researchers in an international and interdisciplinary environment. Experience the high quality of life that Germany offers while collaborating with colleagues across institutes, working and writing in English. We provide you with unique specialist libraries, excellent workspaces, and support in developing your research and your academic career. Apply today. For more information, visit law.mpg.de.
Welcome back to the Lawcast. Thanks for listening to us today. Right, okay, so then they started bit by bit proceeding to incorporate elements of the common law to the colony of India. And the colony of India at that point, was it the subcontinent that we know today, or was it again still partitioned off into different pieces?
Yeah, it was still partitioned. Over India's history, there had obviously been border changes here and there because there were so many of these local societies, princely states. But I would say 1858 and direct involvement by the British is the time period, from this time to independence, which was in 1947, when we see the India that we might imagine or look on a map today. It's forming over this period. So it's an incredibly fascinating period because Queen Victoria, she's almost replacing Bahadur Shah II, the Mughal emperor. And she, in 1858, writes a proclamation which she addresses to the princes, the chiefs, so the native Indian rulers who rule their own little territories. And then the rest of India is now ruled directly from Westminster. So you have the mixture of both, I should clarify that.
Okay, yeah, sure.
So she is announcing to the princes, the chiefs, and the people, and all the people. And she sets out in this proclamation almost a new colonial constitutional framework for the future of India. And it was referred to by commentators at the time as the India's Magna Carta.
Okay.
Yeah, in this proclamation, she represents herself as a peacemaker, and she promises not to meddle anymore in religious affairs. She makes these maternalistic references to protection and the well-being of the people, and importantly, the impartial protection of the law. And she brings in these notions of justice, liberty, equity. They're not particularly well defined in her words, but I'd say that they're presented as being personified in her.
Okay.
Rather than being in the more abstract notions of maybe natural law, religious law that had existed or continued to exist, but now we have this new figure who personifies all these fantastic things.
Did Queen Victoria ever herself go to India?
Funnily enough, no. She never went to India, but she was coronated in absentia, funnily enough, in the Imperial Assemblage of 1877 as the Empress of India.
Oh, the Empress of India, okay.
But it was the Governor-General Viceroy who represented her. She herself never went, and I'm not sure if she took a great interest in Indian affairs, and I'm not sure if she wanted to go, but for various reasons couldn't, or if she didn't particularly want to go.
Okay, yeah. Couldn't jump on an aeroplane back then, so. Let's then talk now. I mean, you're looking particularly about the transfer of laws. Where was the emphasis placed?
So the second half of my project, having charted all of the prehistory and this crossover period, is then devoted to a number of case studies, which considers, as you asked, where was the emphasis placed? What changes were there in the way in which the transferred law was communicated and thought about? And I'm looking at this particularly from an authority perspective. So the case studies I've chosen are codification, the codification of laws, and in particular the Indian Penal Code of 1860,
And that was a codification of British laws at the time, not a codification of Indian laws, but more a codification of the common law.
A little bit of both. So it was codification of English laws as they had been brought over, but it included sometimes elements of existing local customs. Some exceptions might be made in certain circumstances for Islamic or Hindu principles.
Oh, okay,
so
right.
A mixture of both, but really the emphasis being on we're bringing all these laws over from England, but let's write them all down for this specific purpose of us being here as the colonizers in India.
Oh, okay. Clearly, I mean, common law in England is based a case precedent, and probably there wasn't so much codification at the time there. Was this, for them, something novel at the time to codify like this?
Perhaps not novel as such, but I think it's an incredibly remarkable and interesting point that England, although now today there are some areas of the law that have been codified, but by and large it's remained uncodified. Like you said, the common law is the system based on precedent. Mm-hmm. But it was seen, I think, from the colonial perspective of this is a necessary tool to first organize ourselves, but also communicate the laws that we're bringing over. And in England, you didn't need to do that in the motherland. You didn't have that angle.
Mm-hmm. Okay. And so the transfer of law was penal law, for instance. I mean, they left some matters up to the local indigenous population. And there's a desire from Westminster to simplify things, to make it, we've got a very large landmass with, I'm not sure what the population at the time was, but obviously very large in comparison.
In the millions.
Yeah, in the millions, that's right. So this was something also very new for the British to rule such a large populated country. Have you got an example maybe also of how the moral ideals that also were transferred along the way that you could maybe give us there?
Sure. I mean, the Indian Penal Code of 1860 is one chapter. Where the moral kind of stuff comes in, I also have a chapter that looks at the issue of female infanticide and how that was tackled. Without wanting to oversimplify a very complex issue, female infanticide occurred across different areas of India, and it had been a problem for a long time, and it still continues to be a problem, unfortunately. But it was where, across different groups, girls or maybe the second or third female child were often unwanted. A number of different reasons for this, but through the eyes of the colonial British, there were two main reasons which they considered to be the problem, and these were the high costs associated with marriage. It would be the bride's family that would have to pay the dowry and the cost of the celebration. And secondly, the fear that families would be unable to find a suitable match for their daughters. What I mean by that is a husband of the same or a higher caste. Mm-hmm. And it was often considered to be very shameful if you married outside of your caste or outside of your class. So because of these issues and a number of other issues, what I found is that pre-1858, the British focused more on facilitating a kind of self-regulation amongst these Indian groups on the issue, on disseminating messages which often had a moral aspect. These might be in association with Christian missionary groups, but also they interacted with and sought the advice from the Indian people themselves. So they also sent out these messages to say that, look, it's, killing your daughter, it's also abhorrent according to the laws of Islam or Hinduism. Mm-hmm. So there was a lot of this, working with Indian people, disseminating messages, acting as a kind of a mediator and a facilitator. But then after 1858, when the Crown has taken over and there's a keener interest in legislating directly, there was much more of a focus on explicit criminalization, not on the act of murder itself, because this had always been illegal, but criminalizing entire groups and entire families, entire villages, and placing a large emphasis on surveillance. And then how did they justify that surveillance? And this put the British in a very authoritarian position more than before, rather than respecting self-regulation and the commitments which already existed.
Okay, right. And so when you say surveillance, they would actually go into villages and whatnot and control whether the practice was happening?
So they relied a lot on, not constant, but like a lot of census reports based on which investigators would go into certain villages and they would be placed on a watch list. And it might mean, for example, that you had to declare every pregnancy, declare every birth.
Okay, and then that would be maybe then controlled at certain instances whether the child was still alive.
Yeah, exactly. Yeah. So the point being that you've declared these pregnancies, and at any time you'd have this British interference in your home, in your private sphere, which wasn't necessarily there before.
Mm-hmm. Okay, so it wasn't necessarily seen by certain elements, at least of the local populace, as a positive thing.
No, I don't think so.
Okay, right. Moral ideas, that probably gives us a good segue to philosophical ideas that they obviously were involved at the time time in this transferal of justice and the way that the new empress was to rule the colony of India. Can you give us an idea of some of the political, philosophical ideas that were floating around at the time and how they influenced what happened in India?
Yeah, it's a very good question. If I go back a step then to my chapter on codification and the Indian Penal Code, this is where I really examine the influence of the great giant Jeremy Bentham and utilitarianism on the lawyers and administrators who travelled from England to India to write these legal codes. In particular, I focus on, from a biographical perspective, Thomas Macaulay, who is treated as the single author of the Indian Penal Code.
Well, that's an impressive effort.
He didn't seem to have a lot of hobbies, and he didn't enjoy his time in India, so I think it was non-stop, working 12 hours a day.
Get it over and done with. Okay.
Yeah.
Do you know how long he roughly took drafting this code?
I think it was about 4 years.
Oh, wow.
Interrupted for various reasons, illness amongst his colleagues and so on. But yeah, he was there about 4 years.
Okay. And he was a lawyer by trade or a politician or?
I'm not sure actually if he was at the bar before, but he was a Whig MP before he went to India.
Okay, right.
You see the Benthamite influence very clear on him, very clear that both he and Bentham based their ideas on the law was useless, essentially, if it could not be easily communicated and remain, to quote Bentham, notorious in the people's minds. So that was, I think, at the centre of this codification drive, and certainly in the Indian Penal Code.
Okay. Was there an effort then to translate the law?
Yeah. The Penal Code, when it was written, it was explicitly said that it would be translated into the vernacular languages. And it doesn't actually, in this particular preface to the Penal Code, which I looked at, it doesn't give the list of languages, but it does say that it would be printed, published and disseminated in the vernacular so that the people of India will know under which authority and by which laws they are supposed to be living their lives.
Okay. Colonial India is very different to, say, where I'm from, Australia, colonial Australia. You have such a huge population, as we were talking about before. How was the population involved then, or the local populace, in the legal system? Because I'm guessing it's very different from the situation in Australia, where there was obviously no involvement whatsoever. It was seen as terra nullius, whereas there have been empires previously in India and systems of courts set up. How do they then involve the populace there?
Yeah, so another sort of guiding philosophy, I think, throughout this time, all the way up to independence, was this idea of paternal or benevolent despotism. So by this, the administrators and the British defined their rule with a sense that the Indian people could be educated and anglicised, and then they would be able to partake, at least on a surface level, in their own governance. So gradually over time, and of course this begins to change as we move towards independence, but there were sort of concessions made that the people themselves might be able to legislate on a local council level. They might be on matters which were, in the sources they're written about, as being completely trivial, sewage or something like that. That's for them, but they can only do it with the British there to sort of hold their hands. And there were some people who thought, yeah, eventually we will leave India and India will be ruled by Indians, and others who thought that that would not be the case. And I think it goes to your point, talking about this idea of terra nova, that in Australia and other colonies, New Zealand, the British could quite easily, quote unquote, say or make the claim that they discovered these lands. And because they weren't there with a purely commercial drive necessarily, they could make all these outlandish claims. But it was impossible to deny the laws and the civilization that had been in India before. Although, of course, they tried to delegitimize and demonize what had been there before as being barbaric and wasteful and so on and so forth.
Okay, yeah.
Impossible, really, to. And what's at the heart of this project is this idea that it was really from them that the company started to gain this authority, from the existing rulers, particularly from the Mughal emperor. So you can't cancel that out as much as you might like to try.
Certainly, okay, yeah. And were then the local populace involved in the judicial system then?
Yeah, again, like with what I was saying about the development of sort of Indian local councils slowly over time.
Okay.
The British had to, again, they had to rely on the specific knowledge of, for example, the Muslim legal experts and the Hindu legal experts, the Pandits, to explain to them and teach them aspects of Hindu and Islamic law, for example. So they were there from the beginning in a sort of advisory capacity.
Okay.
But over time, we did see Indians becoming judges, But they were heavily discriminated against in many cases. And one of my chapters then looks at what was known as the Ilbert Act controversy, which is where the British government wanted to allow Indian judges to try white defendants. But then there was a huge uproar by the European and white British population in India that, oh, this can't be allowed. We can maybe have Indian judges, but they can't have any explicit rule over us.
I see.
Yeah.
Right. Okay.
So.
Wow. Yeah. Gosh. Well, Erica, they're amazing, fascinating topics that you've talked about today. I wish you all the very best for the rest of your research.
Oh,
and
thank you.
Maybe you can come on again once you've done the PhD.
Yeah.
Okay. Thanks for listening to the Lawcast. If you'd like more information about Max Planck Law, or if you'd like to get involved, please visit us at law.mpg.de.
Max Planck Law. Excellence in legal research.